President, distinguished speakers, judges, Attorney General and friends. On behalf of the School of Law, I'm delighted to welcome you to our annual Distinguished Lecture of 2014. The idea behind this event is to bring together our students, alumni, members of the legal professions and interested members of the public to listen to someone who will raise our sights and challenge us to think in an elevated way about law. We are honoured this year to have as our distinguished speaker Mr. Justice Nial Fennelly of the Supreme Court. Mr. Justice Fennelly, a native of Kilkenny, was born in 1942. He was educated at Clongowes Wood College, took a degree in economics at University College Dublin, after which he qualified as a barrister at the King's Inns. He practiced at the Irish Bar from 1966 to 1995 and worked principally in commercial and constitutional cases, with a particular interest in the then growing field of European Community Law and competition law. He was chairman of the Legal Aid Board, from which he resigned in protest at the level of funding for civil legal aid in 1989. He was also chairman of the Bar Council of Ireland for 1990 and 1991, and was the first Irish lawyer to be appointed as Advocate General at the European Court of Justice, where he served from 1995 to 2000. He was appointed a judge of the Supreme Court of Ireland in October 2000 and will retire from the bench this summer. In the past week, he has been appointed by the government to chair a commission of inquiry into Garda telephone recordings, a topic about which he will not be speaking tonight, no matter what questions you ask. Mr. Justice Fennelly has served with true distinction on the Supreme Court. Like so many great judges, he will be remembered for brilliant dissents in cases like Lobe and Osayande and the Portmarnock Golf Club case. He has also, not surprisingly given his European experience, exemplified the very best standard of judicial dialogue in cases such as MacD and L, to say nothing of his presence in the Academy and in the public square as an authoritative contributor to important debates, particularly on issues of European law. Tonight he will speak on the national judge and the European Union. Our colleague Anna-Louise Hinds will provide a formal response to Mr. Justice Fennelly's paper before we open the discussion to you, the audience, for questions and answers. Anna-Louise is a graduate of NUIG Galway at the College of Europe in Bruges and has lectured in the School of Law NUIG Galway since 2001. She is Editor-in-Chief of the Irish Journal of European Law and is currently completing a doctorate at UCD on the European Commission's antitrust procedures and the rule of law in ensuring effective enforcement. Ladies and gentlemen, please welcome Mr. Justice Nial Fennelly.
President, Dean of the Faculty, other members of the Law School, Attorney General, distinguished guests and visitors, and colleagues in the law, and others. It's an enormous honour that has been conferred upon me to be invited to give this address this evening. I'm overwhelmed with the idea that I could be considered a person that could match the standards of former contributors, so I can only do my best. And you know that my background is A, a barrister for 28 years at the bar, B, nearly 6 years as Advocate General of the European Court of Justice, and now nearly 14 years on the Supreme Court, about to end next month. Now, the national judge is the first judge of the European Union. EU law is our law. It's part of our legal system. It's not different law. It's not something out there offshore. That, I think, used to be the way we thought, and certainly in my youth I did think of international law it was something we didn't really have to think about. Because it didn't matter, we just looked at the acts of the Oireachtas and decisions of our courts. But the European Parliament has put it in this way. Community law, well now we call it union law. Community law remains a dead letter if it is not properly applied in the member states, including by the national judges who are the keystone of the European Union judicial system and who play a central and indispensable role in the establishment of a single European judicial order. Now there's nothing abstract or chimerical about that. It's as true in Galway as it is Sofia or as it is in Palermo. And I want to begin with an example which is really quite close home, and I'm sure about which a lot of you know much more about than I do. We have a decision last year in a case brought by Mr. Peter Sweetman, and it all goes back to the Galway City Outer Bypass Road, for which permission was given by An Bord Pleanála in 2008. It was designed to relieve congestion and to reduce accidents and improve the environment of the city generally. But Mr. Sweetman brought a case in the High Court. He lost. He went to the Supreme Court. The Supreme Court referred it to the European Court of Justice, and the point was this, that the road was going to encroach on a site of community importance designated under the Habitats Directive, and it would pass over 1.47 hectares of karstic limestone pavement of European importance. But it was only a small portion of the area. And so that was the issue that the European Court had to decide on, the question referred by our court. And they came up with the answer. I'm tempted to echo the words of the Advocate General, because what she spoke about, the danger of death by 1,000 cuts. So you can't do just a little bit at a time, and the European Court said, no, this was severe impact since it was taking away that part of the preserved limestone pavement. Mr. Sweetman, described in the High Court judgment as a veteran environmental activist, I think he had campaigned in something like 500 campaigns, and there he won his case. Now, in a way, the story is encapsulated in that. You may know what happened, the bypass road subsequently, because the planning permission obviously had to be quashed and it had to start again. Now, that's just one thing. But there really is, I think, no reserved area of law now which may not be touched or affected by EU law. And the metaphor used by the great Lord Denning in 1973, astonishingly early, just immediately the year the UK acceded to membership of the community. And he said, when we come to matters with the European element, the treaty is like an incoming tide. It flows into the estuaries and up the rivers. It cannot be held back. I'd love to be able to imitate his Hampshire accent, because that's the way he spoke. And that was a case in 1973 involving French champagne producers and the very important objective of making sure that that word could only be used to be applied to that very special wine produced in the Champagne district of France. That was Lord Denning in 1973, and in 1979 he returned to the theme. All this shows that the flowing tide of community law is coming in fast. It has not stopped at high water mark. It has broken the dikes and the banks. It has submerged the surrounding land, so much so that we have to learn to be amphibious if we wish to keep our heads above water. However, the metaphor of the tide is imperfect, because this is a tide that never goes out. It stays in. But to be fair to Lord Denning, he did say the incoming tide. And he said in the same judgment, the first one, the treaty does not, however, touch on any of the matters which concern solely the mainland of England and the people in it. He didn't say anything about Scotland, but he spoke about England. Well, now, he couldn't say that today. And I want to recall the words of one of our own great judges, Seamus Henchy, writing extrajudicially in 1977, the same period, on the effect on the Constitution generally of our accession to the community. And he recognised, Seamus Henchy did, that it was necessarily inherent in the scheme of the EEC that community law shall have primacy over national law. And he commented that member states merge their national identities in a new common law. It is as if, he said, the people of Ireland had adopted community law as a second but transcendent constitution. And that's expressed in a different way, perhaps, what contemporaneously Lord Denning was saying in England. Now, we only need a little bit of history, not too much, I think, but we began with the common market, which was seen, and it was, at the beginning, essentially intended to be a free trade area, to remove tariff barriers and other barriers to trade. You began with trade in goods. And there was a program or a timetable for reducing all of those barriers. I don't know how many people are around, I'd be one of them, who can remember the days when you came in from London to Dublin Airport and you had to open your bags and to have your purchases examined, and people, ladies particularly, who had bought nice skirts in London might have to pay duty on them. It's astonishing to think that that world existed, but that was the world of tariff barriers. And of course, the treaty contained that first objective, free movement of goods. And then it had these other little things in it. Oh, well, free movement of services, free movement of workers, free movement of capitals. These became the four freedoms and became the central objective of the Union. I'll come back to that. There was, in fact, however, one significant and important social objective, even in the very first treaty, and it was the principle of equal pay between men and women in Article 119 of that treaty. And that takes one back to the days of the marriage bar for women in the public service in Ireland, and that this all was axed with our joining of the European community. And, you know, Miss Lefren brought her case as an air hostess in Sabina on the basis that the stewards, the male stewards, were paid higher than she was, and went to the European Court, and the member states came in against her, including Ireland. But she won her case, and that was, on the social field, a first great step. But however, essentially the areas covered by the treaty were these economic areas. And you have goods, and you have services, and you have workers. Now, all of these were pushed forward by a series of decisions of the European Court made on references under the system between the National Court and the European Court, which I'll come back to later. And the European Court applied principles of interpretation, a teleological principle that you looked at the meaning and purpose of an objective. You didn't just look at the word of a piece of legislation. And it applied new principles of proportionality and of legitimate expectation. And in other words, apart from the literal rules, there was a different system of legal thinking that came in with being a member of the European community. Now, there's a one little problem with all these sort of purely economic things, that free movement of workers is just so they can work in other member states. Well, of course, workers are people, and they do things like bring their families with them, or want to bring their families with them, or go to other member states and found families. So that complicates things. It's very difficult to keep things as purely economic. And one of the huge developments then, of course, over the 50, 60 years we're talking about, has been the development in the area of free movement of persons, which ultimately became transformed by a series of legislative acts in the European Community and Union, and ultimately by the adoption at the Maastricht Treaty of the notion of European citizenship. So all of this took place step by step by step by step, which is something that was exactly envisaged by Robert Schuman in the famous declaration of May 1950. Europe will not be made all at once. In the French, it was d'un seul coup. or according to a single plan. It will be built through concrete achievements which first create a de facto solidarity. So you begin from that, and it moves out from there. You have the 4 freedoms, and you have the object which eventually became reduced to one single objective of having an internal market for all of these freedoms. And then you have what was described in one of the great judgments as ever wider fields. And just to give a short list of the areas of law which are now governed by European law: our company legislation, the environment, already mentioned, so that you have to have environmental impact assessment before you get a planning permission. Not only that, a birds directive brought in 1979. I always think, because one of my friends in Brussels was one of the architects of that, an Irish lawyer, John Temple Legge, was also a great bird watcher. And there's really almost no basis for it in the treaty, but he managed to get that put through. And who signed it in May 1979, having just come into power? Mrs. Thatcher. So, ironies all round. And the Habitats Directive in 2000, and then public procurement to provide a level playing field for contracts awarded by public policy, intellectual property law, which interacts very much with free movement of goods and services. There is now a community trademark, consumer protection, package holidays. If your aeroplanes are late, you can bring claims, and one of our airlines doesn't like that very much. Asylum and refugee law, absolutely major colossal area of laws that have become in Ireland in the last 15 or 20 years, has now been subsumed into European law, so that all of these cases, which take up such a huge amount of time in our High Court, form the subject of European law and may be the subject of references to the European Court. Even some aspects of our criminal law, the big one being the European arrest warrant, a single system of surrender of people suspected of crime between the member states, all 28 member states. Even some aspects of family law are touched because of jurisdictional rules about where claims can be brought. I'll come back to one of those. Quite a big thing developing in recent years, the enforcement of UN sanctions in connection, firstly, with the war in Bosnia and other international events such as the wars in the civil wars in Syria and so on. These are enforced now through the United Nations Security Council resolutions enforced by European Union legislative acts and then given effect in the member states. And perhaps the greatest development that has taken place gradually over the years has been in the addendum to the treaties, to the whole corpus of European law, of the whole notion of protection of fundamental human rights, which has moved from a state of no human rights back at the beginning to now the Charter, but I'll come back to that too. Now, excuse me. I have a question. How did we get here? I have a tendency myself to look back and ask, how did we get here? We got our independence in 1922 on foot of the Anglo-Irish Treaty, and we had to found our own courts. And the president of the Executive Council, W.T. Cosgrave, wrote a letter to all the members of the committee under Lord Glenavy, who were to form a committee and a group and make report as to what was to be the nature of the new courts of the new and independent state. And the letter said that we'd had a long struggle to rule our own country. And it said that nothing was more prized among our newly won liberties than the liberty to construct a system of judiciary and an administration of law and justice according to the dictates of our own needs and after a pattern of our own designing, our own courts. But in Article 66 even of the Saerstát Éireann Constitution, there was a provision allowing an appeal from the Supreme Court to the Privy Council. It was extremely unpopular with our newly independent state. Ernest Blythe made a famous speech denouncing it, and ultimately, when the government changed in 1933, it was abolished. by the Constitution Amendment Number 22 Act of 1933, which provided that no appeal shall lie from a decision of the Supreme Court or of any court in the Irish Free State to His Majesty in Council, and it shall not be lawful for any person to petition His Majesty for leave to bring any such appeal. And then you move into the 1937 Constitution itself. Article 5 says that Ireland is a sovereign, independent, democratic state. Everything in the Constitution demonstrates a deep attachment to sovereignty and independence. And the Oireachtas is to be the sole and exclusive body for making laws. The executive power of the state is to be in the government, with the authority of the government established in the Constitution, and justice is to be administered in courts established under the Constitution, and it's provided in Article 34, the decision of the Supreme Court shall in all cases be final and conclusive. And put on top of all of that, Article 29 provided that no international agreement was to have any effect in the law of the state except if it was done by an act of the Oireachtas. So, obviously, all of that amounted to a more or less complete bar and obstacle to our ever possibly joining a body, a supranational body like the European Economic Community, even its earlier stage. So, what we did was we amended our constitution in 1972 in a way which is particularly notable. Adjectives fail me a little bit because I have to come back to this issue of the constitutional relationship in a while. But what we did was we said in the Constitution in 1972, the people said, and at the time of every subsequent treaty, that the state was allowed to join whichever community, ultimately the European Union, to accede to all those treaties, and a provision that no provision of the Constitution may be invoked to invalidate laws enacted, acts done, or measures adopted by the state which are necessitated by the obligations of membership of the European Union or of the communities. So that was more or less, here's our Constitution, but it's like the rivers, like the Red Sea stepping aside and allowing European Union law through. And that's the form of constitutional amendment we adopted. Now, in that context, then, let's look back at what the European Union treaties, and there's obviously confusion of language because up to a certain date it was always called the community, and some of the quotations say community. It's now the Union. But Article 19 of the Treaty on European Union since Lisbon establishes the Court of Justice, and its task is to ensure that in the interpretation and application of the treaties, the law is observed. It doesn't say what the law is. That is left to the judges of the European Court. But it's also addressed to the national courts. And this is where you get the two coming together. Member states shall provide remedies sufficient to ensure effective protection in the fields governed by Union law. There's a very brief picture of the judicial architecture of the European Union. And that is that if a member state is in breach of European Union law, the Commission can bring an action against it called an infringement action in the European Court, and the European Court can declare against the member state that it has been in breach. And in the European Court itself, you have two, perhaps now three, but two basic levels. You have the General Court and the European Court of Justice. The General Court has power to hear what we call judicial review, but annulment actions to set aside and annul any acts of the institutions of the Union. That's the second element of the judicial protection. And the third is, and the one I'm talking about, that is in the member states, that the courts, every court and tribunal, it says, of every member state has the power and the duty to enforce rights guaranteed by European Union law. And then, if there's a problem about it, to refer any questions to the European Court of Justice. So that brings it into the centre, and in that way the architecture is completed, and the European Court of Justice interprets that law, or it has power also to say a law is invalid. And in a famous case in 1986, Les Verts, the French Green Party, the court declared that the community is based on the rule of law. It's a community based on the rule of law in as much as neither its member states nor its institutions can avoid a review of the question of whether measures adopted by them are in conformity with the basic constitutional charter of the treaty. So there you have, for the first time, saying at European level, there's a constitutional charter. I don't think anybody envisaged that back in 1958, the Treaty of Rome. And it says, the treaty has established a complete system of legal remedies and procedures designed to ensure judicial review of the legality of acts of the institutions, and has entrusted such review to the community courts. So you have powerful declarations by the European Court, and the elements are, this is a community governed by the rule of law. Individuals have rights, and those rights are to be protected by the national courts. And that's the key to the structure. Now, I did ask beforehand how many people knew what Fennelly and Luz was. Those of us who've been dealing with European law for a number of years know this as the crucial foundations to sine qua non, not just of European law, but some would say of the very existence of the community and of the union as it is become. And it sets out with the very promising subject matter of urea formaldehyde being imported from Germany into the Netherlands. And the Netherlands reformed their tariff system, and accidentally they increased the tax on urea formaldehyde, and the matter was brought before the Dutch court, which referred questions of interpretation to the Court of Justice. And they're asking the simple question, rephrasing it in every man's language, can they do this? Can somebody just come into our court in the Netherlands and say, under that article of the treaty which says you're not to raise taxes, I can win my case and get my overpaid taxes back? And on that very unpromising material, the European Court founded the notion of the new order of international law. Point number one. That's sort of in advance of Les Verts, saying new order of international law. But secondly, the parties to it, and this is the vital thing, this is not just an international agreement between, it was then 6 member states getting together and forming some form of treaty. It was not that. The parties comprised not only the member states, but also their nationals, from which it followed that the community law has an authority which can be invoked by individuals before the national courts and tribunals. Now, even the original 6 member states confronted with that as they intervened in the court and put their arguments, were astonished with their idea. We signed this agreement. Nobody ever thought that Joe Soap could go into the local court and start talking about it. No, that this is to be all dealt with at sort of very high, elevated level. And it was an extraordinary case, and last year in Luxembourg they had a 50th anniversary commemoration conference, and they produced a book about it. I've just been reading some of the material in that, and there's a surviving le referendaire at the court. He would have been the assistant to the Italian judge at the time, and he has written a very revealing and unique account, because it breaches the sacredness of the secret of the deliberate between the judges. But the history of the matter was that with this astonishing thing that the member states thought were impossible, and the Advocate General thought it was impossible, the reporting judge in the case thought it was impossible. This is just completely wrong. This is a crazy new notion they're coming up with. And what happened? The Italian judge Trabucchi put in a memo saying that the original majority, they were wrong and it should go this way. And ultimately, there was a vote of 4-3 in his favour. So by one person, whichever one of those judges, decided the future of Europe, in effect. And one of the writers in that same volume put it that the crucial contribution of the judgment whether the specific questions under the treaty had direct effect whether that was to be decided by the European Court of Justice or just to be left to the various national courts. And thus was established the decentralized system of justice that became the basis of the entire European project. And the following year, an Italian wouldn't pay his electricity bill of 1925 lire, and he had a large number of other eccentric questions referred to the European Court. But the European Court, which was in a way looking for business in those days, said that the treaty had created its own legal system. It had become an integral part of the legal systems of the member states, and the courts of the member states were bound to apply it. Now, just en passant, that Costa and Enel case really explains how profound the shock was for the legal systems, for the judges and politicians as well, but let's say just the judges in the member states, because the Italians had signed up to this treaty, and that's all they had done. They didn't do what we did, which is to amend our whole constitution to make it subject to European law. They just thought, well, we signed this treaty, and of course to do any of these things you have to go through a whole lot of procedures within Italy, and you've got to refer it all the way up to the Corte di Cassazione, and they have the constitutional orders. The European Court said, rubbish. It has to be applied directly in every court in the member state. So the consequence then is the entire corpus of EU law enters into and becomes integral to part of the laws of the member states, and on at least an equal footing with the laws passed by the national parliaments. And it creates rights in favour of individuals, and the courts therefore are under obligation to apply that law directly, and if necessary to set aside any contrary provisions. Now, it would be a surprise if there weren't some critics, and there were many, many, many. General de Gaulle's Prime Minister, I think after he was Prime Minister, Michel Debré, denounced the court as being guilty of mégalomanie maladive, I think, is sort of malicious megalomania. And a very respected and very renowned English professor, Sir Patrick Nial, in the 1990s wrote, "The European Court of Justice, a case study in judicial activism." Now this, unlike the Debré contribution, was a serious work of scholarship, but he described the court as a dangerous court. A court with a mission, because he said it was a court with a mission, was not an orthodox court. There's a problem with the word mission, because the word mission in French was translated as task into English, but the word mission suited this argument better. So there were different points of view, but the European Court survived all that. And just let's look then a bit at our own experience. Well, we've been referring cases to the European Court since 1973. In actual fact, we haven't referred that many. Up to even 10 years or so ago, we were referring either none or one or maybe two a year. Very few. The last 2 years, I've noticed we've 5 or 6 or 7. That's still proportionately not all that many. We sent 62 references from 1973 to 2011. Denmark was about the same size, sent 141. But nonetheless, we have made references, and we are getting an increasing number of references, and an increasing number of cases where people are relying on European law. And I suppose, broadly speaking, there are 3 reasons for that. Firstly, there are more and more areas of law that have fallen within the scope of European law, and there will be more. Just take the European arrest warrant for a moment. We have a lot of cases about that, but at the moment we don't have the right, because of a decision of our own government, to refer questions to the European Court. That will come to an end at the end of this year. So the arrest warrant cases will be capable of being referred to the European Court. Problems will arise under the Charter, which I'll come back to later. There's definitely, you can hear it all the time if you just listen to the news media, a greater consciousness of the right to invoke rights under the European treaties or under the European Convention. And you hear people saying, I'm going to appeal to Europe, inaccurately saying that, but that notion is out there. And the legal professions, the third point, are certainly more attuned to and more open to reliance upon European law. I do recall a very distinguished colleague when I was at the bar denouncing me for having raised the Euro defence, which was uttered with some contempt. And just let's run very briefly through the sort of cases, some of them technical, some of them more interesting, we've had and that we've referred to from the Supreme Court alone over the last 10 years or so, and that we've got back. We had one case involving SIAC, a very well-known contracting company, and it concerned a dispute about a public procurement, a sewage contract awarded in County Mayo, and normally the contract must be awarded on the basis of the lowest price, but there's an alternative, the most economically advantageous tender. A highly technical matter. The European Court went through the whole thing. We had to do it again when we got it back. And there's an example of quite a technical case where we got assistance from the European Court. Bids was a competition case where there was a proposal for rationalisation of production in the beef industry, and 10 of the larger producers came up with a great rationalisation scheme, broadly with the support of industry and of the government, that a number of producers would be paid to leave the business and there would be a levy on production and they would be paid off out of that and they would be made to mothball their plant and not bring them back into production. And we referred a question which was as to whether, very technical one in one way but very key in another, was this anti-competitive by its very object? I have to confess, personally, I thought it was, and the European Court said it was. It came back, and they still had the right to justify it by saying, well, it would confer economic benefits nonetheless, and looked at as a whole, it would still be capable of being approved and not be anti-competitive. The European Commission very unusually said they were going to intervene in the Irish court in that case, and in fact, at the end of the day, the beef companies withdrew the case. Eurofood is a very technical case involving the liquidation of a subsidiary of a big Italian group, Parmalat, a big dispute between an Irish liquidator and an Italian liquidator, is all related to the jurisdiction of the court. Again, we referred technical questions, telling the European Court the facts. We got our answers back, we applied them. A case that more human, or of human interest, but also illustrates some of the complex difficulties that are going to arise. The Hague Convention on Child Abduction obviously allows people to apply to a court to have a child removed back to the country where the child was habitually resident. And in the J. McBee case involved an unmarried couple who had 2 children. They lived for the man was Irish and the woman was English, and they moved from England to Ireland, and then their relationship broke up. She took the children back to England. He applied in the English court to have the children returned to Ireland, and the English court then referred back to the Irish court a question as to whether he, as an unmarried father, had rights of custody. Now, the fact of the matter was that under Irish law he didn't. But then we had to refer that to the European Court of Justice. This is where it gets really complex. Because we said, although our Irish law says that the unmarried father doesn't have rights of custody, we have now, because of the 2003 Act, to interpret our law in the light of the European Convention. And in fact, in one case like that, in Strasbourg from France, Guichau was the name of the case, the European Court said, no, that was all right, that was not contrary to the Convention. Then Council said to us, but the European Court of Justice might have a different view because Article 7 of the Charter of Fundamental Rights, equivalent to Article 8, and they might interpret it differently in the event they didn't. But there's a very complex system, an international agreement, the Hague Convention, being applied in Irish law according to our constitutional notions of rights of the family, considering the Strasbourg law about Article 8 of the European Convention, then asking the European Court of Justice in Luxembourg what they think about it. So you might think it's a nightmare. One of my English colleagues last week described this as a sort of a mobile. There's so many moving parts. Sweetman case I've already mentioned. We also referred to the European Court. And this is actually a very important case. I won't go into it though. The Pringle case concerning the European Stability Mechanism. Very complex case before our court, but the European Court eventually upheld the accession of the Eurozone member states to the European Convention. And in that case, I'll come back to this later as well, the full court of 27 judges sat. Now, so that would suggest that the system is working well. Well, there are problems. The first thing is that the number of references in the European Court is now growing exponentially, and last year the court had 452 references, which is going on for double what it had only 10 years ago, and which, if you take what is in effect a Supreme Court of Europe, the Supreme Court of the United States, the Supreme Court of the United Kingdom, our own Supreme Court, given the dealing with cases at the top of the system, will decide something less than 100 cases a year. Here is the European Court having to decide 450. And in grand chamber cases like the Pringle that I just mentioned, maybe with a court of 27 members, then it's getting more like a parliament than a court. This seems potentially to be a very serious problem. My former colleague as Advocate General, Sir Francis Jacobs, wrote last year, the year before, that these trends seem to represent a very serious challenge for a court already working at full capacity. And the court, to its credit, is producing replies to the references in an average of 16.6 months. But there is reason to believe that this may give rise to the payment of a price in terms of quality. Now, I was going to discuss a case, a very controversial case of Zambrano, which is an immigration case where, it's impossible to go into detail about it, but it does, I would have to say that the Court of Justice in a grand chamber dealing with a very serious matter came up with a very, very unsatisfactory judgment with almost no reasons. And we have been following it in our own courts for the last 2 years or so. As it's retrenched, come back and back and back from this declaration. It related to the children of a Colombian couple who were unlawfully in Belgium, but because they were born in Belgium, they had Belgian citizenship. And did the refusal of rights to work and rights of residence to the parents in Belgium give rise to infringement of the children's rights? And the court said that this involved taking away the very substance of their rights, which seemed a very strange thing to do, because the citizens, the children were not being deprived of their citizenship. However, there isn't time to go into that in any further detail. We might have reference to it in the questions. There has been one case in recent times where there's some unhappiness because the court actually answered a different question from the one that was referred to it by my colleague, Mr. Justice Hogan, in the High Court. One of the problems is that is in the Supreme Court, final court of appeal, we're under an obligation to refer. If European law point comes up and it's something that's necessary for our decision, we're obliged to refer it. And the European Court then decided that, well, there might be cases where it wasn't obligatory. If it is totally obvious, it was what they call in the French expression, acte clair. Like so many of these things, that's become a term of art now we use in English. Is it acte clair? So helpfully the court said in this case in 1982, which is more than 30 years ago now, that we could, if we were completely clear about what the result would be, we could say we know it, it's so obvious. But the National Court of Tribunal must be convinced that the matter is equally obvious to the courts of the other member states and to the Court of Justice. So we could apply the court acte clair doctrine, thinking it's obvious. If we were satisfied, it would also be obvious to the Supreme Courts of the 28 other member states and the European Union. To say that that's an impossibility is fairly obvious. So can anything be done about this? It's very difficult to see. But this crisis had been in the making for many years, and in the lead up to the Nice Treaty, which goes back to 2000, the former president of the European Court, Ole Due, a Danish judge, presided over a working party, came up with a lot of proposals for amendment of the treaties, and for alleviation of the system so that the European Court would be able to deal with the references, that the national courts would be given more discretion and so on. A very elaborate report. And what happened? Jacques Chirac, as President of France, was in the presidency at the time, and it was all just swept away. They didn't even deal with it in the final negotiations for the treaty, so there were no changes, and there have been no changes since. There are no changes in the Lisbon Treaty. But it seems to me that the time has come for relaxation to some degree of the overall objective, which is uniform interpretation of the treaties. I like what Oliver Wendell Holmes said, not once, but I think in several of his judgments, that some play must be allowed for the joints of the machine. In other words, there should be some room for differential interpretation in the member states. Now, I'm just going to end with two things. Human rights. We've got our own constitution. We've been applying it now since 1937. My colleague Gerard Hogan, and I mentioned already, he came up with the figure the other day that since then, our courts have made 100 declarations of unconstitutionality. So we have a straightforward power in our court to declare a law invalid if it infringes the Constitution, and usually that involves infringement of one of the fundamental rights in the Constitution. Nonetheless, we say that's our Constitution, and in the famous case of Aula in 1960, the Supreme Court refused to give any effect to the European Convention of Human Rights because that was not allowed by Article 29 of the Constitution, which I've mentioned already. But now we've adopted the European Convention on Human Rights Act in 2003, and we've given recognition to the European Convention at a sub-constitutional level. So convention rights are often invoked in our courts, and usually they're very much the same sort of rights in many areas. The right to a free trial, the right of freedom of expression, the ones that come up, the family life, the right to privacy. These are things that are in common. But we now have a new situation, and that is we have the Charter of Human Rights, which has been adopted by the European Union, and which is different from the Convention and different from anything that's gone before, and that this is now a binding legal document. It is part of the treaty. So it will apply directly in European Union law in the same way as our Constitution applies in our law. And therefore, it will. The importance of this is the European Court will be interpreting and applying the Charter in areas where direct legal rights are involved. And there is a great deal of uncertainty about what's going to happen here. Article 51 of the Charter says that it's to apply to the member states only when they're implementing European Union law. But it doesn't appear it's as simple as that, because in a case of decided only 2 years ago on a reference from Sweden, Acapult Fransson, the court said that that was to be interpreted as anything which was within the scope of European law. And that is a moving target. Again, I quote Mr. Justice Hogan, to whom I'm indebted for many of the points I'm making here. He is very concerned that the European Charter of Fundamental Rights will become the instrument which will be most applicable, because there were so many areas of law that will be affected by it. I'm not sure I can share that concern to the same extent, but it is a problem in any event. It is something new in our law. But finally, I just want to say something about the constitutional relationship. I've already mentioned Mr. Justice Henshey's remark about the transcendent constitution. Now, the problem about the relationship between the European Union and its member states and the European Union itself, it's quite different from the single comprehensive constitution that you have in the United States. What the treaty provides, what every treaty provides, is that each member state is to ratify the treaty in accordance with its own constitutional traditions. And there are vastly different ways of doing that. As I mentioned already, in Italy, they've done it by just signing up to international agreement. In England, the United Kingdom, they adopted a European Communities Act in 1972, like we did, a very similar act. But of course, there's a complete difference. They have the doctrine of sovereignty of Parliament, and they can repeal any act any time. We, on the other hand, have amended our constitution, and on one view, this is something irrevocable unless you put it to the people again. But it certainly can't be changed by ordinary legislation. And there are some worrying signs of, let's say, sort of discontent in the ranks. And I just mentioned the United Kingdom and Germany. The United Kingdom, without having a written constitution, has commenced in its Supreme Court to express concern about the interference with its constitution. Lord Reid, in a case, in a very big and complex judicial review case in January involving the high-speed rail link in England, which involved whether they had to have an environmental impact assessment in respect of an Act of Parliament. It was going to be a hybrid Act of Parliament, a mixture of public and private, implementing the policy of adopting the high-speed rail link. And he expresses, just one quote, "As part of a cooperative relationship, a decision of the Court of Justice should not be read by a national court in a way that places in question the national constitutional order." And similarly, the German Constitutional Court has expressed concern, in particular about that European Court decision of Ackerberg-Franzen that I mentioned a few moments ago. So these are serious problems, it seems to me, because I don't see how each individual nation state's Supreme Court could say, our constitution doesn't allow this. That way lies chaos between the 28 member states. It seemed to me that only the central court itself, that's the Court of Justice, should have the power to decide. I was personally disappointed the European Court hasn't, over the years, adopted for itself the role of a constitutional court like the United States Supreme Court, which sees itself as protecting the boundaries between the federal government and the states, and it will on occasion, over the 2 centuries, it has changed its policy from time to time. But the basic point is there, that it can annul a law of Congress if it thinks it's interfering with states' rights. And in the Tobacco Advertising Directive case, which is really my last case at the European Court, and where I wrote an opinion saying that the directive at that time, which proposed to pretty well ban advertising, tobacco advertising throughout the Union, although it was under the guise of a harmonising rule. I recommended to the court that that was an excess of the powers and competences of the community, as it then was, and the court agreed, and it said to construe the article allowing harmonising as meaning that a device in community legislature has a general power to regulate the internal market would not only be contrary to the express wording of the provision cited above, and this is the important bit, but would also be incompatible with the principle embodied in Article 3b, it's now Article 4, of the treaty, that the powers of the community are limited to those specifically conferred upon it. And that's the point. That's what the treaty says. It's limited to the powers specifically conferred upon it. But who's to decide? This is the German notion of competence. We decide because we say we decide. Ultimately, that is a very serious problem. If the rumblings heard from the United Kingdom Supreme Court and the German Constitutional Court lead on further, there could be serious problems. And I query whether we're in a position to follow because we have amended our constitution in a way which may preempt that. Thank you very much.
I'm not going to respond to that except to say that I think it was a truly brilliant lecture and really was exactly what we expected from Judge Fennelly. It is very, very elevated thinking about very important topics. But to do the formal response, and this is the thing that's going to stimulate you to ask brilliant questions afterwards, no pressure, is my colleague and expert in European law, Anna-Louise Hinds.
Just before I start my response, I might welcome some of the people who are standing at the back. There's about 13 seats free here up at the front if you'd like to take a seat. Now might be a good opportunity to do so. Judge Fennelly, Attorney General Whelan, President Brown, Professor O'Connell, colleagues, friends, students, ladies and gentlemen of the audience, good evening. Little did I ever imagine, when I was a second-year student, sitting beside Mr. Justice Nial Fennelly, or Advocate General Fennelly as he was at the time, in the Court of Justice, having lunch whilst on the annual university's trip to the European institutions, that I would one day be responding to his lecture at NUI Galway. There and then began my interest in European law, and here I find myself doing what I never imagined. And it's a pleasure to be here before you tonight, and it's an honour to respond to Mr. Justice Nial Fennelly's lecture. As Professor O'Connell indicated earlier, Mr. Justice Nial Fennelly, having served as Ireland's only Advocate General at the Court of Justice and currently serving on the Supreme Court of Ireland, is eminently well placed to address us on the topic of the National Judge and the European Union. And having listened to Mr. Justice Nial Fennelly this evening, it occurred to me that the scope of his coverage of his lecture tonight is such as to span 4, possibly 5, even 6 undergraduate modules, and at least 2 of our postgraduate modules offered here at NUI Galway on various programmes. And he's managed to accomplish all of this in just 45 minutes. This has highlighted a number of things to me. First, and of course not surprisingly, the vast experience and expertise of Mr. Justice Fennelly. He's certainly a rare combination, an expert in both national law and in European law. And his exposition of the National Judge and the European Union therefore gives us plenty of food for thought, with lots to digest and lots to discuss. Secondly, the expansive scope of his lecture tonight highlights, whether we realise it or not, and I suspect a lot of people here in the audience do realise it, that union law impacts considerably on every aspect of our daily personal and professional lives, and in very many aspects of business activity as well too. Thirdly, and importantly in terms of the topic of tonight's lecture, the breadth of Mr. Justice Fennelly's lecture highlights the extensive role of the national judge, and not just in applying and enforcing union law, but also in shaping and influencing developments in union law. Mr. Justice Fennelly has certainly revealed the extent of this role and the onerous responsibility that it imposes on the national judge from a substantive and an ever-increasing substantive perspective, from a procedural perspective, and even from a practical perspective. He's also exposed the practical difficulties and challenges that arise at the other end, at the Court of Justice in Luxembourg, in terms of this relationship. With so much to unpack, Mr. Justice Fennelly's scope of coverage finally highlights to me that it would be impossible to respond to every single issue that he raised tonight. So I'm going to respond mostly at the macro level, to draw out some of the broader elements of his lecture as I perceive them. And this brings me to Mr. Justice Fennelly's opening remarks this evening. The national judge is the first judge of the European Union. Very often, when we speak about European judges or judges of the European Union, it's the judges of the Court of Justice that we refer to, or that are conjured in the mind of the listener. And the Court of Justice is often applauded, or indeed criticised, or even blamed for that matter, depending on one's stance or agenda, for being at the forefront of the development of union law. Arguably, however, when we look behind the scenes, union law would not have developed in the way that it did without the input and the insights of the national judge. And although credit is often given to the Court of Justice for developments in union law, it is the national judge who has been the catalyst for many of these developments, and ultimately who has ensured the effectiveness of union law. It is the national judge who has referred questions to the Court of Justice. It is the national judge who has drafted questions in such a way as to possibly influence the thinking of the Court of Justice and to shape the outcome of its rulings in preliminary references. It is the national judge who has either adhered to rulings of the Court of Justice or, and in particular the German Constitutional Court springs to mind, it is the national judge who has defied rulings of the Court of Justice, although Mr. Justice Fennelly puts it more diplomatically than I do. And this defiance has resulted in the Court of Justice having to reconsider its opinion or its stance, or at least to acquiesce to the demands of the national judge. Nudged by legal counsel in various cases that led to questions of European law being referred to the Court of Justice, without the national judge, arguably the recognition of the community as an independent legal order whose legal provisions were capable of creating or producing direct effects and being invoked by nationals before their national courts, the doctrine of supremacy of union law, and the judicial discovery of human rights in the community's legal order by the Court of Justice would never have come about. Moreover, without the national judge responsible for applying and ensuring union law would be rendered largely redundant for the individual, and things might be very different had the majority gone otherwise in Van Gendenlus. So it's important to remember that the national judge is the judge who took the plunge in posing the questions to the Court of Justice and asking the Court of Justice for clarification surrounding these doctrines and concepts that led the Court of Justice to read them into community law, now union law. Or it was the national judge's response that ensured their efficacy, or it was the national judge's resistance to them that led the Court of Justice to further develop community law. Without the national judge, therefore, the landscape of union law would undoubtedly look very different to what it is today. Therefore, often unacknowledged, unintended, unaccredited, the national judge has been at the forefront of the development of union law and indeed at ensuring its efficacy. And it has occurred to me, however, having listened to Mr. Justice Fennelly this evening, that it hasn't been all one-sided. It hasn't all been about the national judge applying or accepting union law or enforcing it. And this is because the national judge exercised an important judicial oversight over European law, questioning the interpretation or the validity of union law under the preliminary reference mechanism before the Court of Justice. And beyond this, the national judge has also clearly served to a certain extent as an important overseer of the Court of Justice, particularly from a national constitutional perspective. Without the national judge, the rulings of the Court of Justice in the preliminary reference mechanism, in both the narrower and the broader context, amount to nothing. Where national court judges have been unhappy with the rulings of the Court of Justice, their stance has reined in the Court of Justice. And national courts have not hesitated in voicing their concern in the past or more recently, as in the case of the UK, but also the courts in the newer member states in Poland and in the Czech Republic. They haven't hesitated when the opportunity arises to criticise the Court of Justice, and not always as deferentially as Mr. Justice Hogan. So I'm not convinced by arguments proposed by some, such as Sir Patrick Nial, that the Court of Justice is an entirely uncontrolled judicial authority. Because in a way, the Court of Justice is accountable to the national judge. And I'm also therefore not convinced that the Court of Justice adopting for itself the role of a constitutional court is desirable. The national judge, therefore, to borrow a description Professor Weiler used recently at a lecture of the Irish Centre of European Law in the specific context of the Van Gendenlus case, is the hero of union law, and in more ways than one, or in more senses than just one. And this is the case whether the national judge intended it to be, wanted it to be, or indeed was happy with this result. As for the Irish judge and European law, I don't think I would be mistaken in my understanding of Mr. Justice Fennelly that the reception of European law by Irish judges has been mostly positive in Ireland, and that by and large the Irish judge has adopted what could be described as a pro-communautaire approach, contrasting with the situation in other member states, particularly at the level of the higher constitutional courts in other member states. When Mr. Justice Fennelly started to speak of this, it struck me that this positive stance results in spite of the dualist tradition of our Constitution. But in listening to Mr. Justice Fennelly further, I realised that it's exactly because of our dualist tradition that this positive stance has resulted. Because as Mr. Justice Fennelly pointed out, when Ireland became a member of the then European Economic Community in 1972, we amended our constitution, granting community law a particularly Eurocentric status. Article 29(4)(6) reads, as the judge said earlier, that no provision of this constitution invalidates laws enacted, acts done, or measures adopted by the state that are necessitated by our obligations of membership of the European Union. At times, in various member states, and again, Germany springs to mind, the relationship between the national judge and the European Union law has been taught with tension. A tension that hasn't necessarily been a bad thing because of the positive impact that its effects and its results have led to for for example, the incorporation of human rights protection in the community legal order. This tension isn't even an abnormal thing in a system where the national judge finds himself or herself at the interface of two systems of law, substantive European law and substantive national and procedural law, albeit union law, as my students all very well know, forms part of the national legal system. National judges are, after all, creatures of national law. They derive their judicial authority and their jurisdiction from national constitutions, written or unwritten. They are organs of the state. They are responsible for administering justice in the national legal system, bound to uphold national constitutions, legal norms and values, and bound to apply national law. By virtue of the special status accorded to European Union law by our Constitution, therefore, the tension that has prevailed in other member states does not seem to have come into play between the national judge and European law in Ireland. And when I think about this in the broader context, why should the national judge resist or resent the Court of Justice when this court was created or approved by their member state government to exercise the judicial function, to uphold the law, to ensure the rule of law in a system set up and endorsed by their member states? And why, in particular, should the Irish judge resist union law when it is accorded a special status under the Irish Constitution? From listening to Mr. Justice Fennelly, it seems that the Irish judge has embraced its role as enforcer of union law, and it hasn't hesitated to engage in the dialogue process envisaged by the preliminary reference mechanism procedure when it has been necessary to seek guidance, to seek clarification from the Court of Justice. And the results of this have had an impact not just in the Irish jurisdiction, but beyond. So on this note, I return to Mr. Justice Fennelly's starting point. All our judges are European. And it's the combination of the preliminary reference mechanism, the doctrine of supremacy and the doctrine of direct effect of union law that very much results in the Irish judge being a European judge. The Irish judge is at the interface of national law and European law and sometimes the European Convention of Human Rights. The Irish judge is central to the relationship between the individual and European law. And the Irish judge is very much a critical part of the Union's judicial architecture. Instead, I am left marvelling at how the decentralisation of the judicial authority by the Court of Justice has worked. And it is clear from Mr. Justice Fennelly's discussion that some elements of the system, the preliminary reference mechanism, are suffering or are at crisis point. But by giving the national judge buy-in, by ensuring a role for the national judge in the application of union law, the Court of Justice enlisted the national judge in a very clever way to ensure the effective enforcement of union law. That the national judge would have contributed so much to the development, enforcement and effectiveness of union law could not have been predicted by the drafters of the Treaty of Rome, nor indeed by national judges themselves. And that this would emanate from the only provision in the Treaty of Rome that provided for a role for the national judge and yet limited that role to referring questions to the Court of Justice on the interpretation or validity of community law was most certainly not envisaged. That this has worked, that the national judge is the European judge, is the case, irrespective of the fact that the treaties do not and never have provided for this role, irrespective of whether the national judge intended, anticipated or wanted it to be so, or was even happy with this result, and irrespective of the Eurocentric or the nationocentric outlook of the national judge. That this is so, therefore, is remarkable, and that this is so cannot and should not be taken for granted. The decentralisation of judicial power in the Union by the Court of Justice has been genius, and it seems clear from what Mr. Justice Fennelly discussed that this decentralisation has been the lifeblood of union law. Thank you.
Now,
no, we get the mics back. Okay, now, nobody is allowed to ask Anna-Louise if the judge's speech is coming up in the exam. That's the one question that's not allowed.
It's not.
And I've recently had to look at some of this myself, and spent a couple of hours talking to somebody about the asymmetric triangular constitution within courts arranged polyarchically, which involves another court, the court in Strasbourg, which hasn't got much of a mention tonight, but for which I will fly a little flag because I'm sentimental about human rights. But what I would like now is if you could, I think, respond to the really two sets of really brilliant presentations that we've had, very stimulating, very challenging presentations, with your comments or your questions directed to both speakers would be excellent. We have two private security men going around with microphones. They're from the LLM in public law. They do this as they get credit for this. 1%. So if you want to ask either Aidan or Pat, they will go to you with the questions. You just raise your hands. And don't be shy about being the first person. Somebody here in the third row, yeah. We'll take questions in groups and then we'll go back to the speakers, yeah?
Thanks very much. I really enjoyed the talk. I was just wondering, during the Celtic Tiger, the salaries of judges were put up in according to the review reports of remuneration 1996, 2000, and in 2007 there was also a report that suggested that suggested salaries going up. But and the justification for the salaries going up were that barristers' salaries had gone up that year, and so we need to attract the best barristers that are available. And in the same report, it says that High Court judges and ministers' salaries should be benchmarked, and that Attorney General and Taoiseach salaries should be benchmarked. So I was wondering if you thought that this was a poor separation of powers, in the way that when judges don't want their salaries going down, they say it's a poor separation of powers. And but if it's going up, is it the same? And does it remove the political will to reform a very expensive and legal system that is very inaccessible to the average citizen? Thanks.
Okay, we're going to take clusters of questions. I see the Attorney General shaking her head furiously, and that's in response to that question. So does anybody want to come in, particularly on the papers, or on the two presentations? Yeah? There's Ekaterina down there, yeah. Yeah, no, we're going to take groups of questions, and then they'll all be answered. Thank you.
I was fascinated by both presentations and actually the different directions they took. I'm very much interested in the idea of European Union law becoming some sort of a constitutional law. I'm not saying that it is, but it's an idea which is circulating everywhere, and there is a lot of discussion by professors, by professionals in this field. And on the other hand, Anna-Louise was talking about decentralization and how different judges decide differently and how national constitutions intervene into this system. So just I wanted to hear your thoughts maybe slightly in more detail. How do you think is it possible at all maybe to envisage this European Union law becoming a sort of a constitutional law, constraining somehow national orders, and at the same time being decentralized or polyphonic or whatever you call it?
Very good. Okay. And there's a gentleman down there with his hand up. Yep.
My question is just in relation to there's certain areas in member states that voting to succeed. We look at Scotland. We're voting to become independent from the UK. We see maybe Catalonia, Spain, and maybe Flanders and Belgium. We see like the people in these areas are EU citizens. I'm just wondering, we see Scottish citizens, they no longer, if they vote to be independent, no longer be UK citizens, but I'm just wondering what the European courts, would they still consider them EU citizens, because the treaties do say that member state citizenship and EU citizenship are in effect separate. So I'm just wondering, does I know the Commission says that Scotland might have to reapply. I was just wondering, would the court itself maybe think they have an obligation to protect maybe EU citizens there if they do vote to become independent? And also we look at maybe EU citizens living in Scotland. Would their EU rights no longer apply because Scotland is no longer in the EU? Just like to know your thoughts on that.
Okay, we'll take one more question before going back to the two speakers.
I have a question, Donegal, if I might take the liberty of asking Mr. Justice Fennelly a question. I'm left baffled about how to overcome the practical difficulties faced by the Court of Justice in dealing with the volume of preliminary references that it's facing. And at the minute, the Court of Justice is very much criticised for the tersity and the brevity of its judgments, and particularly in a mechanism that has depended on a dialogue and a cooperation between the national judge and the Court of Justice, and therefore a certain amount of trust between the national judge and the Court of Justice. I don't think that this tersity or brevity of judgment will do the Court of Justice any favours, possibly, and undermine its credibility and even possibly its legitimacy, certainly from the perspective of national judges that are making references to it. So I just maybe would like you to elaborate a little bit on the solution to that, please.
Okay, so we have judges' salaries. We have the big constitutional question from Ekaterina. We have Scotland. And Anna-Louise's question, if you could do it all like really briefly. I'm only joking.
Well, I think, with all respect, I'll pass over the first question, which doesn't really relate to the European Court and national courts. It's concerned with salaries at national level. And I don't think it's a matter which arises in the context of the discussion. But the salaries, just briefly, the salaries of Irish judges are 3 times that of what German judges earn, and twice what French judges earn.
Okay, point taken. Perfect. Okay, that's great.
I don't know that.
Yeah.
Certainly it's not something that comes within the scope of the relationship between the European Court and the national courts. The first question was the EU law as constitutional law. Well, I don't really know how to approach that as a question of definition. I mean, I'm not sure there's such a thing as constitutional law itself. There are constitutions and there are provisions that are in constitutions. And I did speak at the end of my paper about the constitutional relationship between the member states and the Union, and to what extent the European Constitution is represented by the treaties. I think it obviously has to be a case-by-case matter. If you talk about constitutional, substantive constitutional law, it's usually something to do with human rights. And if there are provisions protecting a given right in a national constitution, and also in the Convention on Human Rights, and also in the Charter, yes, you may have that sort of problem. And there, I think you have to look at this sort of mobile relationship I spoke of. I think so far as this evening's topic is concerned, it is very pertinent to the question that was very, very briefly touched at towards the end. That is how is the Charter going to be interpreted? The Charter will apply to the member states when they're implementing EU law. That will mean a decision about that matter by a member state court will have to be given as an EU judicial matter, and potentially with a reference to the European Court. The further implication of it is a hierarchical one mentioned a moment ago by Professor O'Connell. That is to say that if a given national law is held by the European Court to infringe a provision of the Charter, then presumably that provision will be annulled in the same way as we would set aside an act of the Oireachtas which infringed the Constitution. So that's a hierarchical relationship. It becomes a hierarchical relationship between the European Court and the National Court. And it's something different. I think I did say it very briefly, something different from the Convention on Human Rights. Now, the question on citizenship is a very interesting one indeed. Well, as an attempt at an answer to it, European citizenship is defined by reference to holding a national citizenship. So I am not a citizen of the European Union unless I'm a citizen of a member state. That's the definition of European citizenship. So, right, what about Scotland if it leaves the European Union? Well, if that could be very complex in the internal United Kingdom citizenship law, obviously. There may be people resident in Scotland who would be citizens of the United Kingdom or what remains of the United Kingdom. But insofar as they were purely Scottish, if that's possible, because it would become a new species of nationality, then they wouldn't appear to qualify as European citizens. And the final question is, what is the position of EU citizens, that is presumably citizens of other member states who are thereby European citizens who are residing in Scotland? Well, I suppose their position is no different from that of EU citizens residing in any third country until such time as Scotland rejoins as a member state of the European Union. But yes, I suspect that the matter, that resolving those in the event of Scottish independence would be much more complex. It's not one of the things that I've heard debated. My former colleague, the European Court Judge Edward, and I met him in Edinburgh last year, so, I didn't get the impression he was hugely in favour of the referendum, but he did say, oh, well, you know, what does Alex Salmon say? What about the Queen? We'll keep the Queen. What about the pound? We'll keep the pound. But now you're raising the new one. What about citizenship? What about UK citizenship? Well, Union citizenship. We keep Union citizenship. No ready answer. Obviously, there would be some people inside Scotland who would lose Union citizenship, and there's some who wouldn't. That's the best. Now, yes, all right, Anna-Louise. Practical solutions. Well, I think you'd have to go back to the Douay report, which did really attempt to find practical solutions. I suppose the overall problem is that the European Court doesn't have what the Americans call control of its docket. The United States Supreme Court obviously receives, I've forgotten how many thousands, tens of thousands of petitions for appeal every year, and they choose whether what they call to grant cert. And they have a broad criterion for doing it, I understand, which is whether there's a deep split between the states, between the federal circuits. And if there's a problem arising from the fact of differential interpretation, then they'll take the case. Brings me back to, I think, that very attractive notion of Oliver Wendell Holmes, allowing some movement in the joints of the system. In other words, the US Supreme Court won't take the case unless there's a problem. In other words, this isn't a very literalist approach. So some form of filter then may be the answer. After all, the European Court of Human Rights does that. They receive, you're the expert in this area, but they receive tens of thousands of petitions each year, but they can only obviously hear a small number. So some form of rationing at the centre would appear to be necessary. If every state and tribunal, court or tribunal in the member state has the power, not the obligation, but the power to refer, and there's no control over that, with the newer member states getting more and more familiar with European law, it's likely there will be an even more increase. The court has said some things, not terribly strong things, in favour of getting national courts to do the job themselves to a greater extent. I say, so far as the Silfit criterion as the Supreme Court is concerned, we have to be practical about it. We can't refer every case which raises some European points. So if we think it's reasonably clear, there is a certain margin of manoeuvre in the word necessity. Is it really necessary for our decision? If we can find another way of deciding the case, then we don't have to refer. But there is a problem, a real problem there, because the background is another decision of the European Court, the case of Kobler, where the Austrian court behaved in a very strange way. And the court came up with the idea that if a national court failed to make a reference when it should, the state could be liable in damages.
And there's also the possibility the Commission took an enforcement or an infringement action against Spain because
Precisely.
because a national court got it wrong and didn't make a reference to the Court of Justice. So it seems that national judges or national courts might be getting mixed messages. On the one hand, the Court of Justice is encouraging them to take responsibility for making the decision themselves, but on the other hand, they can be sued in damages under the principle of member state liability in damages, or the Commission can take an enforcement action against them.
Yeah, it's a hugely complex issue, but I suspect that a revisiting of the Douay report of January 2000 and some more work, and there are some things like in very technical areas like VAT law, like customs classifications. I just wonder, is there any necessity for them to be decided in Luxembourg at all?
Okay, I'm going to go back to the audience. Any other hands? I see Pádraig Kenna there, who's in the first year of the BCL. Wants to ask a question? And, he's a mature student.
I'm still here. Truly outstanding presentations. Thank you very much, Mr. Justice Fennelly and Anna-Louise, my colleague. I want to say that the hero of the night obviously is the National Judge. I presume we have a few here. You may be honoured and delighted to be here. I want to ask a question about EU law generally, although it's not my area, but I do come across it from time to time. It's my view that most of European law is around approximation, harmonisation and creation of a single market. Generally commercially oriented. In fact, I think EU competition law must be one of the most popular subjects in Europe. Certainly here, we have a very good lecturer here. What I want to ask is, we now have a new creature on the block called the Charter of Fundamental Rights, referred to by the judge here. The question I have is, we are faced with an approach of harmonisation and approximation of civil, political, social and economic rights under the Charter. A completely new project, really, for the courts. And my question here is the National Judge ready for this?
I think Ciara Smith had her hand up as well. Ciara's from the second year of the BCL. And then I think I saw somebody back there. Yeah. Patricia.
Thanks very much to both speakers for such a wonderful evening. So my question is also actually about the Charter of Fundamental Rights. And Justice Fennelly, you touched on this point about Article 51 of the Charter, talking about the fact that the scope of application is only when EU member states are implementing EU law. And I suppose I want to just relate it back to something Ekaterina said about the constitutional nature and this relationship between the Constitutional Court, the ECHR and the Charter. And sometimes, frankly, the Charter is just better than either of the other two. For example, in the area of children's rights, the Charter has a dedicated Article 24 on that. And so sometimes it would be very useful to be able to argue that a particular area of law is within the scope of EU law so that you can gain the traction of the Charter. And I suppose, to be honest, I'm thinking of the situation of direct provision in Ireland, which, as you probably are aware, you can't argue, or you can't immediately, obviously, argue the Charter because direct provision of asylum seekers, we're not opting into the Reception Conditions Directive. But I wonder, can we argue that nevertheless direct provision falls within the scope of EU law for the purposes of the Charter so that we can do things like make child rights arguments to try and counter direct provision? So I just wonder, I would be interested to hear your views on how far the within the scope argument can go.
Okay, and Patricia Conlon was one of our distinguished grads who was on loan to UL for a number of years. Yep. We'll come back in a second. Patricia, do you want to ask it?
Yes, thanks to both speakers. I enjoyed it. It was like déjà vu, in the sense of having spent so many years delving into that area. I had a question, please, to Mr. Justice Fennelly. Did I understand you correctly that there is support for the idea of moving away from uniformity? Because personally, I would regard uniformity of European law as important as primacy or supremacy. While I appreciate the problem with 28 member states, I do think that if we move away from uniformity, we actually begin to destroy the uniform interpretation, obviously, and therefore the common law of the European Union. Thank you.
Okay. Do you want to go back to Ciara for some...
Yes, I'm not familiar with this area of direct provisions, so I'm not sure I can give a good answer to your question.
I suppose my question is, a lot of asylum lawyers would like to legally challenge direct provision, but it's difficult because Irish constitutional law, there doesn't seem to be any readily available arguments, nor are there under the ECHR, but there is under the Charter. And so you're left with the question, can you argue that direct provision falls within the scope of EU law? Now, we haven't opted into the relevant area of EU law.
Yeah.
Nevertheless...
That question seems to answer itself then.
And direct provision, of course, is the system where asylum seekers are housed in Ireland.
Yes.
Does that make sense now?
I think I understand that. Yeah.
Is Tom trying to come in? Do you want to come in at that, Tom?
No, I think what the judge was asking was what direct provision was.
Yes.
Yeah, it's the idea, I think, that asylum seekers come to this country, they are housed effectively in places like Butlins,
yes.
or the camp, and places like that.
So they're support and maintenance.
They're supported directly rather than...
Yes. Yeah.
Okay, so we have the two questions really on the Charter and then this big question on uniformity.
Yes. Well, there's the really the question, is the national judge ready for the application of each of these areas of law which may come in under the Charter? Well, it's true that there are a lot. I mean, the second question illustrates the scope and range of new topics that may arise. But this has been happening now for 50 or 60 years in the courts, and I've been not precisely in this format, but I've spoken at a lot of things over a 20 or 30 year period, and I think at every one of the occasions I could say we're really at a crossroads at the moment. We're never not at a crossroads. Yes, I think that the Charter is partly old hat, and that's what we found in the reference I mentioned about the Hague Convention case, that the court said, well, Article 7 of the Charter is going to be the same as Article 8 of the Convention, so nothing new there, and it's a policy that's in the Charter anyway, insofar as possible. The two are going to be interpreted together, and the European Court of Justice will follow the Court of Human Rights. But insofar as there are new areas outside, that will undoubtedly give rise to new areas of law. And I don't see any reason why our judges aren't as ready as any other judges. But it's not a question that's easy to answer. There's no doubt there's more need for training of judges in the area of human rights law. We had, since the 2003 Act came into force, we had a number of seminars and courses and so on for judges to deal with the Convention, which is really very unfamiliar to them, or to all of us. I always felt that it wasn't enough. We possibly should have had to go back to Convention school, and that might be necessary. But it's a good point, but we just have to cope as the answer to that in the end. Now, the question about direct provision is, as I understand the question, in an area in which there is no legal or statutory obligation, either in national law or in European Union law, then can the Charter be directly invoked in order to confer a direct right to a social provision? Seems difficult to me, but is that the question?
Yes, but it's in an area of law where Ireland is partially opting in, but not totally opting in.
Yes, well, I mean, this is the area where what's meant by within the scope of union law. Again, like risking being a rusty on record, I'm saying this because I've had this discussion with my colleague Judge Hogan a couple of times over the last few days, because we were at a bilateral conference with the English judiciary, and this precise question about the meaning of that word came up. I'm not sure that there's a problem. The Charter says it applies to the member state when implementing union law. And that looks absolutely straightforward if a member state is applying a provision of milk quota or something, allocating a quota or something that's directly provided for. It's more complex where a member state is exercising a right which provided to derogate. Is it implementing when it's derogating? And so, that's one of those judgmental areas where a view may have to be taken. But it's certainly untrodden ground, and it's exactly the area exactly the area in which the German constitution, of course, has put up a couple of red lights and said, no, this is not within your area. The particular constitutional court concerned an act concerning the collection of data about terrorism. And there was, on the whole, it held that the act was compatible with the German basic law, except there were one or two provisions which involved invasion, the violability of the home, which is similar to what we have in our constitution. But then it said that it could not accept, and it's certainly speaking from the German constitutional point of view, any interpretation of the Charter which would say that it applied when there was an indirect effect. If the national law was merely indirectly capable of affecting European law, Union law, then the Charter wouldn't apply. But I think you're posing a more difficult question still. I think you're saying if there is no legal provision, that's what is difficult. I mean, the Charter is a Charter conferring rights. I can't imagine it. Is there anything in it? I'm not familiar enough with it, but if you think, for example, by analogy with our Constitution, the only rights provision that's in it that confers a direct right to a provision is the right to free primary education. There's nothing else of that sort in our Constitution. I don't think the Charter doesn't guarantee rights in the sense of saying states have to provide housing or have to provide social welfare, have to provide unemployment benefits. So I'd be a skeptic in answer to your question. Yes, Patricia. Yes, touche, I think I'd have to say. That's probably a slight bridge too far on uniformity. But there may be scope for certain areas. I think some original thinking has to go into it. Francis Jacobs wrote an opinion back in the mid-1990s about the tariff. And they were, when I was an Advocate General, they were the sort of absolute bore work, if you were found when you were list of assigned cases, tariff classification. Under which heading do you classify such and such a screwdriver? Wonderful work. And he said, this is he didn't actually say, no, he didn't say anything like this, but what it meant was, this is a waste of time. We shouldn't be dealing with these cases. So you may be able to identify categories of cases where there's no, back to rental homes, a little bit of room for movement in the joints of the system in areas where there's not going to be conflict. But I can see, yes, of course, uniformity as a general principle obviously could not be abandoned. I agree.
Okay. Now, I think we're going to continue this conversation at the reception, which is about to follow. But before we do, I just want to say a few brief words by way of conclusion. I would like very much to acknowledge the presence of some people here tonight. In particular, I'd like to acknowledge the presence of the President of the University, Dr. Jim Brown. Dr. Brown has been at so many law events in the past while that we're going to give him an exemption from the first year of the LLB. Because he would find it very useful, I think, to have an LLB. And doesn't have much to do at night time, so he can boost our numbers, because we're a little bit worried. And if Jim Brown starts to do the LLB, everybody will do the LLB. And all the university presidents will come here, and there's loads of them. So thank you very much for, again, coming to one of our events, and again, sitting through the event and listening and being here and honouring us with your presence. It's also the first time that we've had our new Registrar and Deputy President, Professor Paul O'Doherty, among us. He doesn't have quite as many credits at this stage. We might let him off European law. He is a Germanist, so he does know something about Europe, and it's wonderful to have you here tonight. I'd very, very much like to welcome you to NUI Galway, and look forward to working with you as well in the coming years. We also have one of our most distinguished graduates with us tonight, and you're all going to get to meet her and take selfies with her and everything later. That's the Attorney General, Maura Whelan, Senior Counsel. And Maura is a great friend of the School of Law, but she's also a wonderful role model for our students to have achieved such success and to carry out such a difficult task in such challenging times. We're hugely proud of all that you have achieved, and you are very much in a way that you mightn't realise, a role model for our students now. We have you on all our brochures and we tell everybody about you at our inductions. They all call you by your first name and feel as if they know you. And I see sitting behind Tom O'Malley, Judge Carmel Stewart is also here. He's also another wonderful role model for our students. I think there may be other people here that I haven't spotted and I can't see from where I am, but very much like to welcome Judge Stewart as well as another distinguished alumna of NUI Galway. We want to thank a few people for this event. The organisation was done by a person who isn't even here. He's jetting back from Maastricht, and that's our colleague Charles O'Mahony, who's wonderful. He can organise things and not even be here. He sent Cormac, our video man, a lecture or an email this morning saying this is the most important occasion in the calendar of the law school, but don't feel under any pressure. And he did that from Maastricht. And he's a great colleague, and I'm very grateful to him for doing this and other events. Cormac has made 3 videos for us this year. One on the Convention on the Constitution, one on the Ombudsman, and now this one. And we're going to send them out to all our grads in the next few weeks so that we're keeping this connection going with the community of impact that we talk about now in the School of Law. It's not just ourselves, the staff, but it's the students and indeed the graduate community that you are in fact about to join. But the people that we really have to thank tonight are Mr. Justice Fennelly and Anna-Louise Hinds. I think we have genuinely had our consciences raised. We've been elevated by what they had to say, and I'm extremely grateful to them for doing such a brilliant job here tonight. The final point that I want to make, and this is the emotional bit, we do this event, really, I mean, we want you all to be here, but we really want to say goodbye, or we really are sad to say goodbye to our final year students. The idea is that you will leave NUI Galway and your last memory, because we expect your memory may be a little bit shaky later on tonight, but your last memory will be a brilliant lecture, 2 brilliant lectures that you got, and that's all you'll remember. You'll forget about me and you'll forget about my other colleagues, you'll think about these 2, and that will be what you will remember from your time here. But more seriously, we are genuinely sorry to see you go, but we are certain in our optimism that you have a really bright future, and that you will join the community of graduates, very distinguished graduates from this school, like Carmel, like Maura and others, and that you will go on to great success and great happiness, because that's as important, and that you won't forget your school, and that you will always keep in touch, and that you will send us your many children to study law at NUI Galway as well. So have a nice glass of wine at the back of the hall. Larry Donnelly's in charge of it. It's called Putting the Fox in Charge of the Hen House. And we will see those of you who are not final years back in September. In the meantime, can I just say, enjoy your exams, okay?